Google, Facebook, Twitter, YouTube, email, and Bitcoin. Hey, I'm Paul Rabalais, and in this video, we're going to talk about how to deal with your digital assets as part of your overall estate plan. So with technology playing a larger and larger role in people's everyday lives, it is becoming increasingly important to address those digital assets as part of your estate plan. Not only what happens to those things when you pass away, but also what happens during your lifetime if you're not able to get online and access those accounts yourself. So first, let's talk about what digital assets are. It's a broad definition. It's things like your email accounts, whether that's Gmail or work accounts. Social media accounts are part of your digital assets, things like Facebook, Twitter, YouTube. Shopping services like Amazon, and even virtual currency like Bitcoin. And you say, really, my digital accounts, they don't have really any value. But at a minimum, you ought to arrange so that your personal information should be able to be either kept private or deleted when you can't access it yourself or when you pass away, because it can be difficult for those surviving loved ones to have to deal with the fact that they can't access your online accounts. But some of those virtual accounts are really valuable. Many people have that Bitcoin and cryptocurrency. I don't have any of it, but I do have this YouTube channel, which has value. As you may know, every time YouTube plays one of those annoying ads on the video, they compensate the video creator for that. So I want to make sure that that gets, passed along to the right people and the people who can keep that going and keep providing you valuable information. So those digital accounts can have some significant, both sentimental and, quite frankly, financial value. Now, I'll start by saying many states have adopted some version of, I'll give you the long name, of the Revised Uniform Fiduciary Access to Digital Assets Act. They call it RUFADA. Now, the companies that maintain these user accounts containing digital assets, I'm going to refer to those companies that maintain those user accounts as Custodian. And many of those custodians have online tools that create opportunities for you to plan ahead with those digital assets. And under the RUFADA Act, when you opt to use a custodian's online tool, you're rendering all other instructions irrelevant. Think of it like naming an IRA beneficiary. You might put in your will, in fact, I just did a video on this in the last few days. I'll link it to you up there. You might in your will say, I leave my IRA to so-and-so, to Fred, but on your IRA paperwork at the financial institution where your IRA account is held, you might have listed Linda as the beneficiary to receive that IRA when you pass away. Well, when you pass away, Linda's going to get the IRA, even though you said you wanted your IRA to go to Fred in your will. So using a custodian's online tool is kind of like that. It controls. So for example, I went on my Facebook account, which I don't use very much, but I did use the legacy account feature to make sure my wife Amy will have access and be able to do what she needs to do with my Facebook account if necessary. And then with Google, they have an online tool called an inactive account manager that you can use to make certain designations there. So I think as of now, if you are concerned about how your digital accounts would be handled, if that custodian offers you an online tool, go use it, because that's going to control. Now, if a custodian doesn't have an online tool, or if a user doesn't take advantage and use the available tool, then the legal documents that you create will prevail, such as your last will and testament, your living trust, your power of attorney. So it's a good idea to designate these days now, for example, in your last will and testament, you might want to transfer the ownership of certain digital assets to certain people. Or you may want to expressly give your executor certain digital asset privileges to make it easier for that custodian to interpret the will to make sure that the right people have the right authority to do certain things with your digital assets. Not only in your will, but also in your power of attorney. So for example, that power of attorney applies While you're alive, the will covers what happens when you pass away. So in your power of attorney, you may want to give that agent that you named the express authority to deal with digital assets during your lifetime if you're not able to handle them for yourself. So dealing with the digital assets is becoming increasingly important, particularly when you haven't taken advantage of an online tool that a custodian may offer. Now, the downside of neglecting to use the custodian's online tool and relying on the legal documents is now that custodian has to sort through a bunch of legal documents, consult with their lawyers before they can really determine or form an opinion of who has access to your digital accounts and what access they can have. Now, on the third tier, in absence of an online tool or legal documents, then the next thing people go to is the terms of service agreement that custodian provides. So we all know what the terms of service agreement is. It's that thing that you scroll through as fast as you can to get to the bottom so you can click that you accept the terms of service agreement so that you can move on to the website and do what you're trying to do. Now, I will tell you that those terms of service are written, almost always written to minimize the responsibility of the custodian. So I wouldn't just rely on those terms of service agreements to cover all of your digital asset situations that need to be addressed. So we are kind of early in the space of digital assets and who can control things post-death when a user passes away. State laws can and do vary, but I will tell you that this is kind of the first time here in a while that I've really said the traditional estate planning of just I leave things to my 3 children when I pass away, or I name so-and-so as my executor, I name so-and-so as my agent on the power of attorney. That traditional just estate planning may not cut it. Clearly, we're getting to the point now where the proper management and disposition of digital assets needs to be proactively addressed as part of the overall estate planning process. And again, having that traditional will just may not be enough. I will also mention that just documenting or giving people your username and passwords is often typically not enough to handle some of the complications that come with digital assets. I equate giving someone your username and password credentials is kind of like having a really nice car, and then just before you pass away, you hand the key to that car to someone. That just handing them the key to the car doesn't cut it as far as who has ownership of that, doesn't handle all the tax matters and the transfer matters that need to be addressed post-death with the Office of Motor Vehicles valuation issues. So imagine just giving your username and password to people for digital assets is like just handing someone the key to your car. That doesn't complete everything that needs to be addressed to effectively transfer access and ownership of that asset, onto that preferred loved one, for example. So hope that helps with some digital asset information. Make sure you give it the old thumbs up. Make sure you subscribe. That helps Paul out with the old algorithms. And we'll see you next time.